The latest hearing in the Warner homicide case focused on discovery disputes, police interview procedures, and what evidence may be presented to the jury. Defense attorneys argued that investigators failed to preserve key materials, while Michigan State Police described limits within their recording policies. Judge Michael Olsaver ruled on several evidentiary issues and asked both sides to continue producing any remaining materials. During arguments on a motion to compel additional discovery, the defense said the prosecution must turn over all evidence held by investigators, even if prosecutors do not plan to use it at trial.
A defendant is entitled to have produced at trial all evidence bearing on guilt or innocence that is within the prosecutor's control. It doesn't matter if the government intends to call a witness or not. And it doesn't matter, quite frankly, even if we weren't sure that we were going to be calling Greg Hardy now that the government has indicated that they're not. They need to provide all evidence bearing on guilt or innocence that is within the prosecutor's control. And under Kiles versus Whitley, which is another United States Supreme Court decision, this is true even if the evidence is known only to police investigators and not to the prosecutor.
State Police Detective Lieutenant Dan Drewyor described when officers are required to activate body cameras and how those rules differ for uniformed troopers and detectives.
Policy is written as per the position that you have. So a road trooper that's in uniform capacity, has a different policy than that of a detective.
What's the difference between the two policies?
There are several key differences. The primary difference is that a detective or someone on a specialty team, as in the positions that Detective Singleton and I have time, the body camera policy details that we have to activate our cameras essentially during the execution of a search warrant.
Judge Michael Olsaver said the number of deleted messages or missing material does not on its own prove misconduct, and he noted that both law enforcement and prosecutors testified that all available records have been provided.
Again, that last statement is not relevant to a motion to compel, right? So again, we're coming back to the start. You asked me to compel production of documents, production of discovery. In this hearing, both officers have said that they have turned over everything that they had to the prosecution. The prosecution has said that they have turned everything that they received over to the defense, with possible exception of some emails. I don't believe that the phone records of the Michigan State Police are evidence in the case. And I also don't think that simply the number of text messages that may have been deleted speaks to good faith or bad faith. What speaks to good faith or bad faith is whether it was done pursuant to a normal policy.
Prosecutors also argued that text messages sent from the victim to the defendant are admissible because they show motive, marital conflict, and the defendant's state of mind in the days before her disappearance.
Your Honor, the defendant in this matter has pleaded not guilty, and in Michigan, a plea of not guilty puts the prosecution to its proofs regarding all elements of the crime charged. We cited extensively to People v. Fisher in our brief. The Supreme Court placed the evidence into 9 different categories, and here I kind of pared it down to 4 categories. The trial court in that case ruled that the oral and written statements made by the victim that were known to the defendant were admissible. The court ruled that these statements were not hearsay and were relevant to the issues of motive and the element of premeditation and deliberation, and the Michigan Supreme Court agreed. Your Honor, Exhibits B through E are all text messages that are from Miss Warner to the defendant. So those are specifically not hearsay by definition and are admissible as they go directly to his state of mind and the, again, issue of intent and premeditation and deliberation.
The court took several issues under advisement and ordered both sides to continue turning over any remaining materials. The case returns to court next month for additional pretrial motions. I'm Brian Vish for WLEN, Lenawee's local news station.